When someone passes away, their property is distributed in one of two ways, either through probate or outside of probate. What passes outside of probate? Many people think that the last will and testament controls everything. Nothing is further from the truth. Many things pass by contract or operation of law and skip probate altogether. Your 401ks, IRAs, investment, and other accounts, if you've set beneficiary designations properly, they don't go through probate. This money will go straight to your beneficiaries. However, if the beneficiary is a minor, then the money may be held by the company until they turn 18, then a lump sum paid out. Many people don't realize that the beneficiary designation on accounts such as 401ks and IRAs can supersede the instructions in a will. That means if you don't keep your beneficiary designations up to date, your assets could end up going to someone that you don't want them to go to. For example, if you get divorced and don't update your beneficiary designations, your ex-spouse could still inherit your retirement account or life insurance. To avoid this type of situation, it is important to review your beneficiary designations regularly and update them as needed. Additionally, if you have multiple accounts with different beneficiaries, it is important to make sure that the overall distribution of your assets is still in line with your wishes. Otherwise, you could end up leaving some of your loved ones out in the cold. Now, if these accounts don't have a beneficiary or the beneficiary fails, then they go to probate. In certain cases, real estate avoids probate. It's a common misconception that real estate must always go through probate to be transferred. If the deed is properly prepared and lists more than one person, then the real estate may pass outside of probate. This is because the language of the deed will determine who the rightful owner is. So if the deed is in order and it lists more than one person, then the real estate will pass outside of probate. If the deed has more than one person on it with the correct language, the real estate passes outside of probate. If the language is tenants in common or it is the last survivor of a married couple, then the property will probably fall into probate. If the deed was joint tenants with the right of survivorship and the other person is still living, then it is an automatic transfer. However, when the last owner passes away, if nothing's been done, then it will go to probate. Much like IRAs, your bank accounts, will be paid to the people who are named on the account if you've set up payable on death without probate. Accounts without any designation go to probate. If you put your children on the accounts, highly not recommended, then those accounts will pay to them as a joint owner. Many people choose to put their children on their bank accounts as joint owners, thinking it will give them access to the money when they need it. However, this is not always the best idea. If you have put your children on the accounts, then those accounts will pay to them as a joint owner, regardless of who you've given them permission to do so. This can lead to problems if your children are not responsible with money. Additionally, if you must go to court for any reason, the judge may order the assets in those accounts frozen until the case is resolved. As a result, it's generally advisable to keep children off the account. And as far as your cars, Arkansas does have transfer on death titles. If your car meets all the criteria, you can retitle it to pass at death without probate. Your other property will go to probate, and here's how it's distributed. With a will, the rules of the will are generally followed. Without a will, you're considered intestate, and your estate is subject to intestate succession. And here are the rules. The living spouse, if any, gets 1/3 of the real estate as what's called a life tenant. This means they can live there, get money if the house is sold, rent it, and they can't be removed. But if the house is sold, then they get a portion of the third and your children get the remainder of the money. When the spouse passes, the children get the house free and clear. The living spouse gets 1/3 of the money and personal property. The children get the other 2/3 of the money and personal property split evenly between them.